Good afternoon, everyone, and welcome. I'm really excited to be talking about privacy developments this year, what we should be looking at, what we should be focusing on. And I have a wonderful group of guests to join me here to share their expertise with me. First, we have Rob Corbet of Arthur Cox out in Ireland to give us his perspective from across the pond. We have uh, Omer Tene from Goodwin, formerly from IAPP, who will have many perspectives, and Kenesa Ahmad from Aleada, a privacy consulting firm. And finally, Gabriela Zanfir-Fortuna from the Future of Privacy Forum, who focuses on worldwide privacy law and development. So, welcome everybody. And I'd love to just jump right into the big question, which is there anything going on in privacy in 2023? In particular, what do you have your eye on? What issues are you really focused on? What things do you think will happen this year? What notable things should we have on our radar screen? And so let me begin. I think first with Omer. Want to get your perspective, and then we'll just kind of go one by one, and then we'll drill down on some of these issues.
Okay, thanks, Dan, and a pleasure being here. I'll note that 3 of the 4 speakers are current or former Future of Privacy Forum, so it's nice to sort of reconvene. 4 quick points on what I see in 2023 kind of focused on. AI, machine learning, I mean, large language models, ChatGPT, and recently the Bing still experimental chat search have captured the public imagination. It's front page of the New York Times today, and I think it was yesterday also. Really incredible stuff. So I think this is the year when we see AI sort of going mass market. In fact, it has, with the entire sort of plethora of really dense tech policy issues that it raises: privacy, civil rights, equity, fairness, and content moderation. Next week, actually, the Supreme Court of the United States has a hearing on the Google case, so that'll garner, tremendous attention. So AI, state laws, we are really inundated with client work, trying to implement or prepare for state laws. Of course, the CPRA amendments to CCPA came into force together with the Virginia law several weeks ago. Colorado and Connecticut are coming into force in July, and Utah in December. And who knows, we might very well see some others. Kids' data, all the way from the top. State of the Union address, President Biden addressed this issue in his speech. There are a couple of pretty mature proposals, bipartisan proposals in Congress, COSA and COPA 2.0. And California passed the Age Appropriate Design Code Act back in August. It's coming into force next year. But it requires a lot of prep work, so companies are thinking about it. And my 4th point would be health-related data, specifically reproductive health, as an upshot of the Dobbs decision. But not just. There is, I think, a broad understanding now that HIPAA is quite limited in its reach. It's a law that dates back more than 20 years, and there's a lot of health data that's not captured by HIPAA, or even not health data, but data that can reveal sensitive health information, for example, precise geolocation. We all have been watching the My Health, My Data Act coming into focus in Washington State. I think it'll pass. So that too is, I think, a point to emphasize this year.
Kenesa, what are your thoughts on some of the new developments?
Well, Omer, I think you hit all the buzzwords: children's privacy, AI, LLMs. Definitely going to be a front of mind, very timely. Always also thinking about the impact of these new laws that are coming into effect, not only the new overarching state privacy laws, but the children's laws, how companies are going to operationalize the requirements, looking closely at specifically how companies are complying with upholding consumer rights that are now being afforded to folks outside of the scope that we're familiar with under CCPA. So now employees, applicants, applies to B2B data, thinking through the consumer identity verification intake process, especially in light of the recent FTC kind of investigative sweep on mobile apps. Part of the review was focusing on businesses that failed to process consumer requests submitted from authorized agents. So thinking through the implications of those new opportunities for submitting consumer requests. Also thinking about, of course, I'm in California. Eyes are not far from the California Privacy Protection Agency to see what kind of enforcement comes through. We all know Ashkan Soltani, the former FTC technologist. They're going to be staffed with folks who understand technology, and I think that's going to bring rigor to the enforcement actions that we haven't seen. Well, so interesting to see how that shapes up. Thinking also about this umbrella of digital trust that privacy sits under. There are a few different frameworks. The World Economic Forum has one, PwC. So by digital trust, I'm referring to this interdisciplinary view of how to make trustworthy decisions regarding the development and deployment of new technologies. So to Omer's point about how we're deploying AI, who's going to regulate it, and so on. And it's this umbrella under which privacy sits, but also security, safety, transparency, interoperability. So there's a lot to unpack within those larger frameworks and how we think about privacy, and it fits within those frameworks. And then it's also interesting to think about the fallout from this massive implosion of blockchain-related projects in 2022. There's some projects that, and purportedly, that try to preserve privacy in transactions, and those have typically drawn a jaundiced eye from regulators because it's not easy to or obvious how to verify the identity of individuals involved in those transactions. So those projects were always pushed to the fringes, and now with a lot of the big leaders in the blockchain tech industry going down in 2022, I think regulators are going to have new pressure to regulate, protect consumers, and may have even less desire to let projects like these that purportedly focus on privacy preserving in tech transactions to allow them to thrive. So there are a few tied a bit to what Omer was speaking to just a moment ago.
Rob, what are your thoughts? What's going on in Europe, and what's it look like over there?
Nothing much going on over here, really. Nothing to see here, folks. I guess there's the old chestnuts and the new chestnuts, right? There's, in terms of the stuff that's keeping us busy here, the old chestnuts like data transfers and trying to grapple with any sort of certainty around the future of data transfers. So we've got pending decisions of the European Data Protection Board around the meta transfers from the EU to the US. We're all waiting on the EU-US data privacy framework and whether or not the European Commission will push that ahead, notwithstanding reservations expressed by the European Parliament only this week, which is echoes of previous concerns that were voiced in relation to the likes of Safe Harbor and Privacy Shield. So that old chestnut will continue to run on. There's an obsession in Europe, as people will know, about transfers from Europe to the US. Goodness knows why they aren't obsessed with transfers anywhere else, but that's we could talk about that one all day. I think the other old chestnut is the issue of GDPR enforcement. I borrowed the phrase of snakes and ladders from a colleague in relation to trying to navigate the complex web that is the GDPR's cooperation and consistency mechanism. So those decisions that we've started to see come through here, I suppose just as the EU is obsessed with transfers to the US, EU regulators and courts seem to be obsessed with Meta. So if you look at a series of landmark decisions by the Data Protection Commission here in Ireland that went through the dispute resolution mechanism before the European Data Protection Board and has resulted in those kind of headline grabbing fines over the past year or so, we're going to see more of those precedential decisions. The EDPB is talking a good game about doing a better job of getting through those cases in a more harmonious way. But we've seen the Data Protection Commissioners take an annulment action before the European Court of Justice in relation to some of the directions that have been sent in their direction by the EDPB. So there's still a lot of snakes and ladders to be played, I think, on the issue of GDPR enforcement. In terms of new chestnuts, today is the first real day of the new digital agenda in the EU, because today is the day by which online platforms have to publish their numbers of monthly active recipients of service, which is a beautiful expression that comes from the Digital Services Act. So many entities that aren't very large online platforms, so the entities other than the Googles and Amazons and Microsofts and Metas of this world, will come within the scope of the Digital Services Act. And I think the thing to watch there is well, the Act itself doesn't come into full force until the 17th of February next year, so this day next year. Certain provisions require attention well in advance of that. And on the privacy side in particular, I think it'd be interesting to watch how the digital services coordinators that will be established under the DSA, how they'll take on an enforcement role under the auspices of the European Commission in matters that will necessarily traverse across privacy and the role of supervisory authorities like the Data Protection Commission. I think for the companies themselves as well, having to develop a compliance function that lines up with the requirements of the DSA will be a new departure for many technology companies and platforms, for example, where the level of compliance that will be required of them and the independence of that compliance function and so forth will be, think DPO+++ in terms of the expectations of regulators. And then more broadly echoing what's happening in the US in relation to the identification and removal of online content that's harmful or illegal. Again, there'll be a lot to be done there by many companies that are deemed to be hosting services under the DSA. So that's the first step in this whole digital governance agenda. We will see another game changer, I think, in the Representative Actions Directive, which comes into play in the middle of this year, which will give a quasi-class action right in relation to actions including GDPR actions for civil compensation. And there's lots of other stuff we can talk about in terms of Data Act, Data Governance Act, and indeed the AI Act that will probably finalize this year as well. So lots of stuff we can dig into if we'd like to later on, but certainly no shortage of activities to be keeping an eye on.
Gabriela, what are your thoughts?
Well, I feel like I owe this conversation bringing in some of the developments outside of the transatlantic space, even though indeed a lot of the tone is set by what's happening, particularly in Brussels, right, with this new age of data regulations, with the enforcement of the GDPR, which, as Rob was also pointing out, is kind of reaching maturity. It's 5 years after the GDPR became applicable, so I think it was about time that we see some of the big decisions in the big cases. Plus, we're seeing more and more complex analysis. We're seeing the regulators looking at things that are quite, again, complex in terms of the processes involved. So that's definitely something to follow. Now, if we look outside of the transatlantic space and try to look a bit at the bigger picture, this year we'll continue to see new laws or significant revamp of laws around the world. Only yesterday, 2 days ago, in fact, Australia published their plan to revamp the Privacy Act, which is a culmination of a process that started about 2 or 3 years ago. Now we have all of the proposed amendments, and my understanding is that the expectation is for these amendments to be introduced as a bill sometime this year, and that's the process to kick off. Vietnam is very close to adopt a data protection law finally with their decree. They've made some steps in this sense. Of course, India, everybody's still looking at India. We've been following that process for a couple of years now. Now we have a new bill that was published by the government after the old bill was withdrawn last summer. So the expansion of the comprehensive data protection law model inspired by the GDPR is continuing in the world. However, I'd say that there are some attempts to bring data protection regulation a bit closer to the age of algorithms and AI that we're experiencing right now. And what I hear is that in the Australian amendments, for example, there's a sense of a bit of an upgrade to the data protection model. Now, I'll have to dig a bit deeper into that and see if that's indeed the case, but those were some of the reactions of the experts on the ground after they read it. Speaking of AI and algorithms, I would want to highlight this one point that we're seeing some regulators in the data protection space, so data protection authorities and privacy commissioners, starting to enforce data protection law against AI systems, algorithmic decision-making systems, automated decision-making systems, which I think it's quite interesting. We are seeing regulators in Europe creating departments that will be focused on AI. So most recently, the CNIL announced that they will create a department that will be focused on AI. The Dutch Data Protection Authority created or is in the process of creating a department to focus on algorithms. And I think that we will see more and more of GDPR data protection laws applied to this complex processing of personal data, which ultimately underlie AI systems. And this will happen in parallel with development of actual law that will apply to AI systems. As we know, in Brussels, we're looking at the EU AI Act, possibly being finalized this year. There is a possibility there, but that's not the only thing happening in this space. Brazil actually made significant steps towards proposing an AI law, which we're thinking will be introduced in Senate this year, in the Senate this year as well. The process has started already a couple of years ago. So we are at the stage where we'll actually see the bill being introduced in the Senate as well. Yeah, so these are some of the bits and pieces that we're paying attention to around the world.
So really not much happening. And it seems that the general trend is, there's more enforcement, more laws, more places, more stuff going on. But I'd like to drill down on some of the things that we discussed. And I think one issue that I'd love to talk about is AI. And it seems that, now, we're in the, everyone's waking up to AI. Being conscious of AI, pardon the pun. But what is AI and how is it different from other privacy issues? AI is a kind of type of algorithm, but we've had algorithms for a long time. We've had machine learning. How and you know, the laws thus far have, you know, focused on it from privacy, although what we're seeing now and from what you're telling me is that, you know, we're seeing developments of laws specific to AI that really targeting AI. And you know, there's an overlap with privacy, although there are other issues raised by AI that aren't exactly privacy. But what angle should we be, you know, where do you see things going in terms of tackling this? And then how does the law, if it's going to look at AI separately, how does it kind of define what falls into AI and what is just an algorithm or what's just automation? You know, the EU for a long time, you know, from the GDPR and the directive prior to that had regulated automated data processing, but, you know, had a, you know, define that as anything that doesn't involve, you know, that's purely automated. But there's a lot of automation, you know, with some small amount of human involvement. And there probably will be AI with some small amount of human involvement. So the distinction between, you know, pure automation and human is a kind of a muddy one. Just like the distinction of, you know, if it involves an algorithm, we should regulate it as AI would mean AI would regulation would swallow up everything. So I'm wondering if folks have thoughts on, you know, exactly like where is this going? And then if this is a separate corner of the world, you know, what, you know, where are the boundaries of this corner going to be? And where are the laws pointing to? Does anyone want to jump in on that and solve it?
Oh, yeah, I will absolutely solve it right now, Dan. But I wanted to jump in because your question is something that I've been thinking about in the past 3 years a lot. And we actually started a cluster of projects with my team at FPF about 3 years ago, where we were looking at how the GDPR is applying to automated decision making. And we have a report on case law. We found 70 cases or so at that point around this time last year when we finalized that report. And I wanted to jump in to say that I think a lot of what underpins what we call AI systems, like this general blurred term, which I don't believe any of us can define, frankly, right now. But I think a lot of what underpins the systems, when they affect individuals and when they are built on the data of related to individuals, will trigger application of data protection law as it was developed in Europe, because the definitions are very, very broad of personal data and of processing. So I wanted to bring up a decision that was actually given yesterday by the German Constitutional Court. And as those of you in listening that are scholars in privacy know that the German Constitutional Court has been developing the field of data protection for decades now, with their decision in the 80s on informational self-determination. And the German Constitutional Court yesterday found that the laws authorizing police authorities in the German state of Hesse to rely on predictive policing algorithms are unconstitutional because they breach the right to informational self-determination as provided by the German Constitution and derived from the right to human dignity. I'm mentioning this to highlight that I think this is where we'll start seeing why Europeans some time ago decided that data protection and privacy, as we call it here in the US, are actually two different things. And I think in this particular debate with what are we doing about algorithms and automated decision making, this will actually make a difference, and we'll see more and more data protection derived from the rights of dignity, not necessarily the right of privacy being relevant. Where does all of this leave what's happening with the AI Act? We don't know, and I think actually the definitional challenge is one of the challenges that it's tough to solve in the current negotiations in Brussels. It's one of the things that are mostly debated there. I think I saw Rob wanting to intervene.
Maybe I'll just chip in there. I mean, I think the direction of travel, if you think of this as a privacy issue evolving into a bigger issue, I mean, the Europeans have had a go at this by, regulating profiling and automated decision making, specifically within the GDPR, and identifying types of profiling that are regarded as particularly harmful from a pure privacy perspective. And if you look at the AI Act, it's way more of an ethical framework rather than principles-based kind of regulation like the GDPR has been. And I think that's going to be really challenging, because I think the Europeans have been brave on AI actually by putting together such a comprehensive piece of text around AI and categorizing certain AI as either prohibited and just unacceptable, or high risk, which is the stuff that will attract the highest level of regulation within the EU, and then the rest of it, which is kind of like go on and go forth and multiply AI, that is probably going to be embedded in all of the products and services that we end up using every day of the week. So the way I think of it is that we'll have to get our heads around ethical concepts around duties of care that are owed to the ultimate users of our products that embed AI. Providers and importers and distributors of AI products will have very specific compliance obligations in relation to how they design their algorithms, how they track performance, how they inform users of their AI systems about how to use the systems properly, gathering log data from users of AI systems and catching malfunctions and bugs in the system so that the AI can consistently improve and so forth. Well, that might be more like plumbing stuff. The rest of the law is probably largely ethics-based and having to do your own risk-based assessment around the types of harms that might be generated from your AI in any particular use case is going to put a very heavy onus on, in particular, the providers of the AI systems, but also even on the users of the AI systems to meet what I think Europeans will expect to be a similar sort of standard to the human rights standard for privacy. It'll be almost like an ethical standard that's expected before you can deploy AI within the EU. So very much like Gabriela was saying there, that the privacy and data protection pieces might start to evolve a little bit, and there might even be an ethical framework that takes on a whole life of its own. And maybe in 5 years' time, instead of talking about the GDPR, we might be talking about the AI Act in the EU has become the standard of AI that's driven the agenda more globally,
Yeah, I think that's really interesting because AI. Oh, Omer, do you want to hop in here?
Yeah, though I didn't mean to interrupt you, Dan. So maybe you should complete the sentence. Sorry.
Oh, sure. I was just going to say that what I think, privacy, focuses on, starts with, the gathering of a person's personal data. Typically, is when a lot of the laws are triggered. AI gathers data in mass and could even gather de-identified data and train itself on that. And then it will involve decisions made about people. And some of those decisions will involve, gathering personal data to make decisions on people. But a lot of, I think, the AI issues come from the decisions. And a lot of the privacy regulation deals with, things that have to be resolved at the time of collection. So I think there's going to be this interesting challenge as we focus on AI, because it's going to shift the focal point a bit more away from collection and a bit more to decisions that could be made down the road. And it's tricky because I just think that there's a lot of things that we're used to doing on privacy, a lot of things we're used to focus on, individual rights and individuals being given notice and a decision being made about when you can gather data, all of which AI is really going to involves, but also involves a lot of other things, involves decisions about people. So I think it's a good thing that we're going to shift this focus, but I think it's going to be very hard because it's going to create a really confusing combination of privacy law and law dealing with AI that's going to overlap, not totally overlap. There'll be a lot of areas that are not overlapped, and then a lot of confusion on when one law would apply versus another law. So I think we're really in for quite a mess when this goes. It's not going to be as easy as it might seem. Oh, we'll just add some AI regulation into the mix. So that's my prediction: is we're going to have, it's going to be really hard. It's no surprise, but sorry, Omer.
I'd love that for a title of an article. One of your future articles. We're in for quite a mess because I think that's absolutely right.
I like this distinction then that you're making between the collection stage and the use or decisions in this context. Of course, AI, you asked, what the definition is, and I have to say, I'm not sure you usually are good at defining things and laying out the taxonomies. I don't know if we've reached the singularity moment. I know Meta's chief scientist argued a couple of weeks ago that we haven't, or at least that, the large language models that we're seeing aren't that necessarily. They're not thinking for themselves. They're just statistical models. Be that as it may, I think, as you say, some of the issues are kind of the typical privacy issues, collection of data for training sets, access to data. Can you delete if you're included? But there's also, Jules and I have our theory of creepy. We kind of distilled the concept of privacy into this adjective of creepy technologies. And few things are as creepy as the story that came out today about a search engine kind of running amok and telling a user that it's in love with him and wants him to ditch his spouse. So the word creepy actually appears today on the front page of the New York Times in this context. So that too, I think I see it as a privacy issue. Of course, there are the decisional kind of challenges that you're talking about. I always go back to Danielle Citron's article, Algorithmic Due Process. She wrote it like 15 years ago, but it's incredibly prescient. And, certainly when inscrutable decisions kind of coming out of a black box are reached with respect to kind of life-altering pivot points in the context of employment or education, the judicial system, one of the speakers mentioned. It's very troubling. Like, can you challenge? Can you understand the logic? Can you appeal? I think another big challenge of AI regards content and disinformation and potential for AI or whatever it is we're talking about to disrupt or corrupt the truth, namely, just trying to figure out if the information that it's giving us is based on fact or just on sort of statistical models. And needless to say, that has profound sort of implications for democracy and for public discourse. And then I'll also mention the potential of AI to disrupt and replace entire professions. I think with ChatGPT, we have immediately, sort of understood that this could sort of almost instantly herald the demise of customer service representatives, for example. But in the slightly longer run, maybe even of lawyers. I asked it to write a privacy policy, and it produced a pretty nice one, and in like a non-billable second. Sorry about that, Rob, but we may need to find a new calling. Those are the main issues as I see them. Kenesa.
Yeah, I'll add to that. So I've been listening to all of you talk about just how hefty an issue this is, and how we don't even have, seems like, the right even terminology to be talking about the issues that have evolved from what we understand the privacy related AI issues, and now what we're grappling with today. And so I come back to this idea of digital trust, these frameworks that are taking, it's a very lofty idea. We're trying to pull together privacy, security, again, safety, interoperability, auditability, fairness, so on, all under this one umbrella. And perhaps that's the way that we're moving when we're talking about privacy and AI. Maybe that's the direction. Thinking through just generally what are reasonable measures that we need to deploy to make sure that this technology is going to be deployed responsibly in a trustworthy way. What does that even mean? So that folks can make their informed decisions about what technology to trust. And it just raises, again, these really tricky questions that, if you're in the privacy field, you've been grappling with for some time, between privacy, security, the balance, data governance and compliance altogether. But yeah, Omer also, it's really interesting to think how it's going to disrupt our industry specifically. There will be an impact. There's no reason to think that, we won't be impacted just as much as every other area, content, competition, and so on. It's going to stretch just all regulatory structures and legislative efforts to constrain it. It's pretty fascinating, and we'll see what's left of us in the end when the robots rise up and take over.
If I may, before we move to another topic, I just can't help but thinking that back in the late 60s and early 70s, when all of this idea of data protection, data privacy started to appear in policymaking, lawmaking processes, the fear that was actually meant to be tackled was not about how do you tick boxes for consent notices and things like that, but the problem that is very, very nicely described in the old Phipps report from '74 and in all of the literature from back in the day, had to do with automation, with what's going to happen with decisions that are fueled by files that are going to be computed about individual persons. So a lot of what motivated the adoption of those first frameworks on data protection law actually had to do with what we are seeing today as a reality in terms of algorithmic decision making, profiling, and all of that. Just wanted to put this nuance here as well, because this whole field that we all work in was not created for privacy policies and for us to sign consent forms to have a photo taken at an event and things like that. Those were not the biggest issues that wanted to be tackled by this. Now, was this the right tool to meet the challenge? We don't know. Perhaps yes, but it wasn't developed as in the most effective way. But yeah, I wanted to also leave it there in the conversation.
So I want to shift gears, which we could talk about this. This could be the topic of a whole session. To talk a little bit about some of the developments. In particular, I'd love to look at enforcement and writ large, because it covers both enforcement in the U.S. We're going to see the enforcement of some of these new state laws. We see the FTC continue its forward march. As well as issues going on in the EU with enforcement, trying to harmonize it. Also, the fact that it's been stepping up. And I guess besides the sort of general trend that we're seeing more enforcement, do folks see any kind of larger takeaways or a picture on kind of where is enforcement going? Are there new directions in enforcement that we're going to see? What's the read on kind of like where is enforcement evolving to? Are we going to see something new on the horizon, or more of something on the horizon that is different than say a few years ago?
I can give you a quick one on that to kick it off, maybe from this side of the pond. Speaking from Dublin, it's going to get different quickly, because there'll be different regulators established this year and into next year. So there'll be digital services coordinators in each EU member state that will have competence under the whole Digital Services Act regime, and the European Commission will be front and center in a way that it has traditionally been, perhaps in the area of antitrust or competition law. In particular, I think they'll focus on what they're calling the very large online platforms and the very large online search engines, but not exclusively. I think you'll see a proliferation of new companies that act as kind of intermediation companies with larger platforms. So there'll be a whole new business in leveraging off the powerful data held by some of the platforms, and also public sector data that's held are locked within public sector systems at the moment. And you'll see a whole new ecosystem develop around that, and a whole new type of harms that will emerge from that, which will probably relate to privacy in certain respects, but also relate to other areas, hence the mess that we have potentially in front of us. So I see, and in both cases, in relation to both digital services, AI and privacy, they will continue to have the stick of the fines piece, which will grab all the headlines, but also the individual right of complaint and right of action that will be driven by individuals, but also by advocacy groups who will start campaigning for better practices, but also litigating for compensation. So that will drive the agenda, and maybe that's a good thing, or maybe the cynic in me says that's not a good thing, and that might drive people to pick on pet topics that will drive their own individual agendas, rather than lead the enforcement efforts into areas where it might do the most benefits for society, like Omer mentioned, misinformation, and Kenesa mentioned children's data. There's certain areas that can and should be getting a lot of regulatory attention and enforcement. But when all of the attention is being driven by privacy advocacy groups around slightly silly issues like data transfers, excuse the heresy around my data transfers things, and cookies consents, and the kind of form filling that Gabriela mentioned, when all of the enforcement effort has gone into that, there's a skepticism around whether the new regime will drive effective societal change at a time that the pace of AI is going to manifestly impact people in a way that we've never seen before, and notwithstanding that the concerns have existed since the 1960s and 70s. I think the scale of machine learning and ChatGPT has brought it to life, as Omer said, because people can now visualize the power of AI and the potential applications for their own lives, even their own professions, as we've discussed. So there is no certainty in my mind that the enforcement regime is going to step up. It's a decent effort by the EU to create a regulatory environment with an enforcement regime, but I can see it being really problematic when you're trying to apply it across 27 different member states. And back to the fundamental point, do we even all agree on the terminology of what we're trying to regulate or the principles behind which we want to regulate? Because I don't think there's anything close to alignment on that, even as between the EU and the US.
I think that's really tricky. That's the harmonization question. You know, the GDPR was supposed to harmonize things, and it looks like there's been a little bit of a snag or a problem that still needs to be really hammered out because the GDPR isn't really harmonizing, and we're seeing a lot of tension there from especially with Ireland. But I think it's just sort of this larger question of, you know, how can this really be harmonized? And what is this going to look like going forward? And I think there's a lot of energy being put into harmonizing that's sort of totally separate from the issue of substantively what things should they be looking at. And when it comes to the private right of action and private groups, my general picture, unless I'm wrong, is that, you know, in the EU, it's much less robust. That you know, in the US, you have a very robust litigation when there's a private right of action. But the EU, you know, it's always everyone saying like it's going to take off, it's going to take off, but I haven't seen it yet, and it's been years. So I just wonder, you know, will it really take off? It's the specter, you know, the ghost that everyone thinks is going to appear, but I'm not sure it is.
If I could actually sort of draw threads from what both of you said, Rob and Dan. First of all, Rob, I couldn't agree more that, well, there is a sense that there is more enforcement now in Europe, like Gabriela highlighted. It seems to focus on, you know, if I may offer, the wrong things. And it's like the technocratic aspects of privacy, the data transfers and cookie banners, cookie consents, which are not consequential in any way to individual lives. Whereas, you know, even enforcement actions that have happened, for example, you know, in Ireland, the public services card, that's a much more impactful and, you know, important enforcement case. It gets very little attention in Europe. On this side of the pond, Dan, I fully agree that the private right of action is sort of mega consequence. And I think it's the reason that the law that has garnered by far the most enforcement focus is BIPA, the Biometric Information Privacy Act in Illinois, which has a private right of action and has just spawned, you know, like a whole wave of cases, litigation by individuals and class actions, some of them incredibly, you know, interesting and nuanced, and some of them less so. I think where that points here in the United States is actually to where there is a lack of enforcement. Because, you know, granted, we see more enforcement by the FTC, by the attorneys general who have these powers now, with a focus on children, on healthcare-related information. But there are still big gaps because of the lack of a comprehensive privacy law in the United States. So, for example, entire sort of swaths of the data brokerage industry are still completely unregulated in this country. And they, you know, enable a shocking array of data practices which impose very real and concrete harms on individuals, on communities, and especially on communities with less power, you know, sort of suffering from poverty or discrimination or lack of equity. So I think what could really ramp up enforcement is if a law passed, like, for example, the ADPPA, which was the draft federal privacy bill that almost made it last year, which had a private right of action. I think that would sort of, launch this entire field to kind of a new level.
So a question also on the, do you want to weigh in on this, Kenesa?
Yeah, just a quick note. I also come back to the how-to of the enforcement. Mention the California Privacy Protection Agency, which is completely new, staffed heavily with technical personnel, which is new to enforcement, and it's gonna be interesting to see how it shapes up. We know that there's been enforcement fairly recently regarding compliance with global privacy control, GPC, the riser signals, and coupled with the work by watchdog groups like Consumer Reports and other think tanks that have been taking similar approach, like FPF, CDT, EFF, use these methods of deploying some type of technical measures for actually to do testing that drives some of the enforcement efforts. I think we'll see perhaps more of this private, kind of non-profit watchguard mixed solution to help drive enforcement with someone like Ashkan in the seat at the CPPA.
Gabriela?
I wanted to weigh in on the enforcement debate as well, to mention that I think we are not paying enough attention to the DSA and the DMA in Brussels. I think particularly the DMA will have some extraordinary effects due to the positive obligations and ex-ante obligations they have for platforms to not merge personal data that they gather from their different services in the absence of GDPR level consent. This being just one of the rules that has significant overlap with the GDPR, and that will actually be enforced by the European Commission directly. And this, the Commission never enforced data protection rules before. So how will that play out? That's a big question, and I think Rob was spot on to point to the DSA and to this new wave of data strategy type of regulation, and the role that the European Commission as an enforcer will actually play. That's very, very important. I would also want to bring the global aspect again, and I think that the Brazilian Data Protection Authority will start being more active after having been built in the past couple of years quite attentively, and I think that we'll start seeing enforcement of that regulation of the LGPD over there. And generally on enforcement, I think that this combination of several regulators that are looking at the same thing, consumer protection authorities, antitrust authorities, data protection authorities, will indeed bring more interesting and more complex actions, enforcement actions in the space that we're watching.
Yeah, so it sounds like, we're in for more chaos. But, and while I think chaos is very worrisome for companies, I actually think it could be a good thing, as for the reasons you point out, Gabriela, that, a lot of new ideas are being tried, a lot of new approaches are being tried, and we still don't really have, good answers for a lot of these things. So it's time. We need more experimentation in the lab, and it seems like that's what we're going to get. On the other hand, it does create a world of great uncertainty for companies doing business to know what they're supposed to do. But that's sort of, I think, a big growing pain that we're going to have for a long time as these things get worked out. I do want to leave with one final question, which is the state regulation. We have a number of bills coming up in the states. Companies are scrambling to try to figure out how to comply with the existing state laws, which have some differences, but they also have a lot of similarities. A lot of them are versions of California, a little bit lighter, a few times where they're a little bit stricter, but generally they're variants of that. And there's more on the horizon, and I'm wondering, as more come up, what do you see that direction going? Do you think we'll see some new requirements in these laws that go beyond California? Because if a state passes a law like Utah, you don't have to pay attention to it because it doesn't really add anything to the debate. But if you have other laws that do add new wrinkles to this, that then creates some, I think, new developments in the law. So I'm wondering, are there things on the horizon that are going to really effectuate some changes rather than just add another state to the list? What are your thoughts, Omer?
Yeah, so as you know, and I think mentioned, and some states already have an opt-in requirement for sensitive data, and that, of course, is sort of a big shift from California, which is just opt-out, including for sensitive data. So the default, of course, rules the day, and it's very important. I do want to highlight the fact that some states are innovating with more specific privacy laws. I mentioned the My Health, My Data bill in Washington state. And by the way, it's not just states, it's even cities. New York City has a law about the use of AI in employment decisions, and it has a law about protecting tenant privacy, including geolocation information used by landlords. So we are certainly seeing a lot of innovation. But back to what I said when we talked about enforcement, I think the real threshold sort of moment is when a state adopts a private right of action in one of the general privacy laws. Florida was on the cusp for some time and then sort of scaled it back. Once that happens, I think it's like BIPA, but not just biometric data. Again, it will drive some change, maybe leading again to pressure on Washington, D.C. to act.
Any other thoughts on this one? So any other final thoughts? We are almost at the end. Any parting words that anyone has? Any answers or questions?
A quick one, I
Chat
think.
GPT.
Yeah, go ahead, Kenesa.
Oh, just a quick note. Chat GPT did say that one of the 2023 trends would be advancement in AI-based privacy protection, according to my chat last night. So we were right.
So maybe AI will solve privacy, which would actually be sad, because then, that takes over our jobs, which would not be good.
I was just going to say, increasingly the law is going to require you to self-assess risk and have it independently audited and verified. That'll be a game changer for companies. And one of the things you need to keep a close eye on is preserving legal privilege in relation to how the sausage is made in the sausage factory, because I think the gory details of how algorithms are built and the harms that are known or suspected that might be derived from technology are going to have to be documented now, and regulators will have a right to demand the information behind that. So I think dust down those old law textbooks about legal privilege.
Yeah, no, I think that's a really interesting question and attention. You know, if we're going to rely on risk assessments, I think it's great that there be transparency and that those go to the regulator, and it creates rigor, because these things could just be done in a rather cursory fashion and shoved into a drawer and be meaningless paper. On the other hand, though, if you do them really well and thoroughly and really identify the risk, then it creates the laws that require transparency, or laws where they could be not privileged, and or the regulators can see them, drives a sense to be really careful and cautious and lawyer them up so that they don't really identify the risks. So there's this tension of, you know, how do we get truly honest, really good, thorough risk assessments, create the right accountability, and not have them clash, because the more accountability, it sort of would lead to kind of weaker assessment. So I don't know the answer to that, but I see that as an upcoming problem as laws are trying to want both, and those things are in tension.
I think you just saved our profession, Rob. At least we can offer you privilege.
And I just wanted to thank you, Dan, for the invitation to share this wonderful conversation on a Friday afternoon, evening for Rob. Thank you so much. And definitely the privacy space, it tends to grow and be more significant and more complex. And I think I feel good about our jobs, regardless of ChatGPT.
Well, great. Well, thank you all. And we can thank everyone here is guaranteed. I promise everyone here is a human being and not an AI avatar, but maybe one day we can dispatch our avatars to do this for us. But for the time being, we're seeing a big expansion. And every year when I think it can't get bigger and can't grow more, there's more issues, more countries passing laws, more states passing laws, different types of laws. It really is becoming quite large and quite enormous, where it might almost be impossible for us to do our jobs without AI to help us keep track of everything, because it's getting so big, complicated, and expansive. Thank you all for a really interesting conversation. We could keep going and going because there's so much to talk about. But it's been wonderful sharing this Friday afternoon with you. Take care, everyone.
Thanks, Dan.
Thank you.